And now, welcome to EIPs, tax returns, and judicial orders in the context of domestic violence during the COVID-19 era, sponsored by the ABA section of Taxation. If you are seeking CLE credit, you must attend the entire program. Partial credit is not available. Please click on all the participation attendance verification alerts during the program to confirm your attendance. Immediately after the program ends, a link to complete the certification process will appear. Please complete the evaluation and CLE affidavit, providing your bar information as requested. Once the completed form is submitted and your attendance verified, your certificate will be emailed to you. Moderating the program today is Gina on. Gina, you may proceed with the program.
Thank you. I'd like to briefly introduce the rest of today's panel and agenda. Joining me today in the program are Andree, who served as the Director of Indiana Legal Services Low-Income Taxpayer Clinic from 2006 until her retirement in 2017. Despite having worked for ILS for almost 40 years before retiring, she continues to work as a volunteer attorney for the LITC and regularly provides training to other lawyers, advocates, and law students on a wide range of tax issues. Judge Bernadette D'Souza is the first permanent domestic relations judge elected in New Orleans as the Orleans Civil District Court. She is the president of the National Association of Women Judges. Prior to her election, Judge Bernadette D'Souza was a legal aid attorney for 18 years at the Southeast Louisiana Legal Services, managing the Domestic Violence Unit. She served as an adjunct professor of Tulane Law, teaching a course on domestic violence and the law. Jill MacNabb has been an attorney advisor with the Taxpayer Advocate Service since 2008. Prior to joining TAS, she was a clerk at the U.S. Tax Court. Nancy Rossner is a senior staff attorney for the Community Tax Law Project, a low-income taxpayer clinic located in Richmond, Virginia, serving the entire state of Virginia. Nancy has been with CTLP since 2012 and represents taxpayers in income tax controversies before the IRS and the Virginia Department of Taxation at all levels of controversy. Jim Smith has been an attorney with the Legal Services Alabama since graduating from law school in 1978. Although he now works in Montgomery at One Place Family Justice Center, he began in Selma, Alabama, litigating voting rights cases which, despite the apparent incongruity, directly led him to representing domestic violence survivors as victims of human rights abuse at a time before there were any DV programs or laws in Alabama. Today we have a packed agenda which I will briefly introduce. First, we begin with an overview of domestic violence in the context of COVID-19. Then the panelists will review the law of filing status and potential sources of evidence from family court. Our third section will cover EIP and superseding returns, and our fourth presentation will discuss innocent spouse relief and disclosure. Finally, all the panelists in the last part of the webinar will discuss advice for clients and frankly for us as practitioners from all their unique perspectives, whether it be as a legal aid or tax advocate, IRS practitioner, or judge. So first we'll begin with domestic violence, how nothing and everything has changed, hearing from both Jim Smith and Judge Bernadette D'Souza. Take it away, Jim.
Thanks very much. Domestic violence is defined differently from different perspectives. Sociologists, mental health professionals, domestic violence victim advocates, family law lawyers and judges, and the criminal justice system all view it somewhat differently from different perspectives. However, fundamentally, it is domestic violence is a pattern and deliberate course of conduct. It's a history of conduct. It's not a one-off incident. While a one-off incident may be completely inappropriate, obviously, what we're talking about here is a history of conduct. And it's designed not for the abuse in and of itself. It is designed to maintain power and control over the victim. That is the portal through which violence is evaluated appropriately. It's the touchstone, if you like, of domestic violence. And the violence is over an intimate partner or family member. Some of the statutes run off into the weeds, into encompassing all sorts of individuals. However, I think for our purposes, we're focusing on what we refer to as intimate partner violence. And while physical violence is certainly what people think of oftentimes, is what you hear in the news as domestic violence, that's really a small piece of the puzzle. There's physical violence, and there's verbal abuse, emotional and psychological abuse, economic abuse, abuse or threatened abuse of third parties, children, for instance, and physical, social, and familial isolation. Again, these are tactics that are used in consort. The power and control wheel, some people may have seen this referred to in various presentations or run across it in various places. It's designed to really wrap your head around this notion that physical and sexual assaults and threats, while they may be the most apparent and visible aspects of domestic violence, what they really do, what the physical violence does, is it sets the predicate for the effective use of other tactics that may appear more subtle, less obvious to the outside world, but are altogether as effective and perhaps even more effective in obtaining and maintaining the desired goal, which is, of course, power and control. You can't say power and control over again often enough when evaluating domestic violence. That's the long game for the batterer, for the abuser. The conduct is deliberate, goal-oriented towards power and control. The physical injuries may be the most obvious, and certainly physical violence is a crime in and of itself. However, it's not the goal of the batterer, because physical violence is a crime, and committing a crime may lead you to be arrested, and that's kind of the antithesis of power and control. When the batterer gets put in handcuffs and led away, he's lost power and control. So that's not really what he wants. He wants to maintain the power and control. We'll look at a couple of these in terms of the current situation with the pandemic. Isolation is a critical thing to consider when people are sheltering in place. It can be certainly an effective public health tool in the time of a pandemic. However, if one is sheltering in place with one's abuser, it becomes its own tool for power and control and can create its own public health crisis. There's no escape. If the abuser lives with the victim, they may not transport may not be available. The abuser may never leave. Friends and family may not be willing or able to take the victim in an emergency. Shelters may be no longer accessible. Courthouses and social services may not be fully functioning. And the authorities may not be willing to evict or eject the abuser from the household. States have put in restrictions on evictions, and that may be great for a lot of our clients, but in the case of a domestic violence victim who's trying to flee for safety or may not be able to extricate the perpetrator from the house, and she may have nowhere to go. So it becomes a tool the sheltering in place becomes a tool in itself for isolation. Economic abuse, it kind of goes at the heart of what we're talking about here today. Controlling the finances, all the money may be in the abuser's bank account. He may dole it out as an allowance or force the victim to beg for money. Again, reinforcing the notion of power and control. Economic impact payments may be directly deposited into the abuser's account, even if the parties are separated or divorced. The refunds, the EIP payments may have gone to the batterer and may be used as a tool to reel the victim back into a relationship, even if she has successfully fled. While abusers may control the money, the victim may be forced to incur all the debt. A problem that we see often in relationships, making it impossible for the victim to, or feel impossible for her to flee the relationship because she is dependent upon the abuser for making the payments. She has the liability, and on top of that, if the abuser threatens to leave, he leaves with the money and leaves without any liability, and that becomes, again, its own tool for exerting power and control over the victim. Other tactics that batterers use, they disseminate the information about the pandemic, potentially to the victim. May use his position of power to frighten the victim, to prevent her from reaching out to family and friends. It's not safe. Reinforcing that. To prevent the victim from seeking medical attention, withholding insurance access, doubling down on controlling the finances, EIP rebates, unemployment compensation benefits, using the pandemic and the public health emergency to rationalize his need to maintain the victim's isolation and to reinforce, again, power and control. Reduced access to support and exacerbated risks. Programs that provide services to victims have been significantly impacted by the pandemic. Shelters may be full. They may have closed altogether. They may be compromised by positive tests for workers and people who are already in shelter. Survivors may fear seeking shelter out of concern for contamination and infection. Other supportive services may no longer be available. Senior centers, counseling centers, ER rooms. People may be afraid to go to the ER. Many domestic violence shelter programs meet victims at the ER room. Well, that may not be acceptable anymore. It may not be a safe place. People may feel uncomfortable to go there. Legal aid offices may be closed. Courthouses may be closed or have limited access. The resources that may have been there in the past may not be there anymore. Judge, you have anything you want to say about any of that?
Yes. And this is where I'd like to come in, you've done a great job in identifying the dynamics of domestic violence. Those are the issues that I see in my court when I'm handling a protection order case. All of the dynamics that Jim talked about play out in my courtroom in terms of testimony and as allegations in the petitions for protection from abuse. victims that come to the courthouse oftentimes have suffered tremendously, and many of you probably know that it is very difficult for a victim to make that decision, to take the step to finally end a relationship and get a court order to keep the abuser away from her, and in some cases when there are children in the family. The reduced access to the courts for pro se petitioners, we thought during the pandemic that has been a really a problematic situation, because as Jim mentioned earlier, public transportation was not available. People were afraid to drive someone to the courthouse. And so whoever came to court in Orleans Parish, the courthouse that I sit in, there is always a judge that is on duty. So every temporary restraining order was signed by a judge. The numbers were not all that great initially. There has been a number of cases now that are being filed, but during the months of March and April, it was very difficult for victims of abuse to leave their homes for the fear that they would not be able to then have a roof over their head or a roof over the head of their children. And oftentimes I've heard in some of the cases that I've already had protection orders, is the defendant would literally tell the victim, the courts are not open, you're not going to get me out of this house, no one is going to hear your case. So they're constantly reminded that they cannot get the relief that they would like to seek. So that's what has been going on in New Orleans, in the city that I sit. The reduced access, I think I'll let Jim talk about the Montgomery County, Alabama's Judicial Information System. Go ahead, Jim.
Okay, thank you, Judge. Setting a little predicate here, in Alabama, attorneys are required to e-file everything they file in court almost. Not allowed to paper file anything. Pro se litigants may only paper file, usually in person, sometimes usually at the courthouse. The protection from abuse petitions that domestic violence victims can file to get restraining orders, protection orders, they're designed to everywhere in the country for people to be able to file those pro se with standardized forms. In Montgomery County, in the 2.5 months before the courts locked down, effectively on March 16th, initial filings in domestic relations court by lawyers, there were 175 cases filed by lawyers, 192 by pro se litigants. Pro se litigants file more often than lawyers file. In the 2.5 months following that, from March 16th to June the 1st, lawyers filed 164 cases. It was all electronic, and a reduction of only 6%. And lawyers pretty much didn't miss a beat. Pro se litigants, their initial filings dropped to 74 cases, a reduction of 62%. I think it pretty clearly illustrates what the pandemic has done when courthouses have reduced access, that lack of access to the court means that domestic violence victims in our cases have less opportunity to use the civil justice system. And if lawyers are not as available, the lawyers they reach out to, which would be legal services lawyers, they are, again, this points to increased isolation, and the burden is placed on victims of domestic violence.
Yeah. In Orleans Parish, in New Orleans, I saw the same challenge that Jim talked about in Montgomery County. Legal services lawyers were not able to file directly or do e-filing because there was a cost associated with it. But due to the pandemic, the clerk of court decided in order to allow victims of abuse to do e-filing would be the better route would be going to a legal services office and having an attorney e-file. So they waived all costs for legal services lawyers to enable them to e-file directly, helping victims to get their petitions for protection through the courts. Pro se litigants, our cases went down, like I've explained earlier, due to the transportation issue and not knowing whether courts will be opened, or with the power and control tactics that have been used by perpetrators of the violence. But for now, our numbers are steadily going up, both by attorneys as well as pro se litigants. Most of the OutTROs that were initially signed were suspended until the opening of the court. So all the existing TROs were in place until May the 22nd. And so we've started doing all the protection order hearings now because those matters were all reset to after May 22nd. But the new TROs were signed 24/7 by a duty judge, literally coming down to the courthouse and placing the order in the hands of the pro se litigants. The next slide talks about Chicago. In Chicago, the number of people seeking help increased significantly in recent weeks. During the first week of March, I believe they had 383 people that called the domestic violence hotline in the city. And by the end of April, the weekly number had already soared to 549. So you can see that the pandemic puts the pressure on, as Ms. Byron said. No one can go stay somewhere for a few days, have family come over, have the kids go stay with grandparents. All those safety supports weren't accessible to victims of domestic abuse. Now, I do have to let you know that in New Orleans, I was told when I spoke to the director of the Family Justice Center, they were helping a lot of victims. They had a hotline set up through their Family Justice Center, and they were placing victims of abuse in hotels. There were several of the hotels in downtown New Orleans that were graciously offering hotel rooms for victims to flee the domestic violence situations in the household. So there were several other measures that were being put in place during the pandemic, even though the shelters were not open in New Orleans. Jim?
Okay, we're about out of time here, but mention the people will often ask, why did she stay? Why didn't she just leave? Well, it's fear, and fear is the bottom line of that. The most dangerous time for a victim is when she does leave the abusive relationship. That's when the power and control that was working is no longer working. Batterer feels as though he's lost control, and he ratchets up, becomes more desperate, and it is demonstratively more dangerous for the victim to leave. There are loads of other reasons, obviously, but it comes back to fear, and fear. What can you do? Well, you can listen, believe, and bear witness. Do not pass judgment. Resist the urge to make sense of crazy, because you never will. It's crazy, aberrant behavior. You go with it. It's life. It's Alice through the looking glass. Just go with it. Don't try to make sense of it. If it makes sense to you, then you got to start worrying about yourself. Maintain eye contact. Express concern for the victim's safety. That's essential. And recognize you don't have to have all the answers. You just have to know to whom you can refer the victim to for assistance. That may be DV programs, safety planning, counseling, civil legal services, law enforcement, culturally competent resources. Judge, anything last?
No, the last one would be, how has the process to assist DV victims changed? And basically, legal aid programs have truly ramped up. Their call centers and their staff attorneys are helping to field the calls while they are still at home. They're accessing their local offices and helping victims of abuse. They're conducting interviews and appointments. I have been handling a lot of my hearings with the staff attorneys at the Legal Services Office via Zoom because of the concern that their clients sometimes do not want to be in the courtroom in person for the fear of the pandemic, being exposed to it. They have little children. All those concerns now are being creatively and innovatively handled through a Zoom hearing. The courts have relaxed the signature and notarizing requirements. In fact, what we do is, if a victim of abuse comes to the courthouse, we instead of having, because there is no notary on site to notarize the petition, the judge that's on duty or domestic judge will swear the party, ask if the allegations are true and correct, and basically accept their petition. Like I mentioned, we have moved to video trials. I only will do in-person hearing where people are being challenged by the program of Zoom, or they don't have the adequate bandwidth for their internet. So I conduct all hearings in the morning. We have staggered our docket, so there are not very many people in the courtroom. I want the public to feel comfortable that if they come to court to be heard, that we are following social distancing guidelines, and we have set up all the necessary precautions that need to be taken. Referrals can be made through the call centers that most legal aid offices maintain. Nothing works quite as well as establishing a personal direct relationship that can be called upon in these times of crisis. So if you do not have one, now is the time to start. Do you have any take on creative remedies, Jim?
No, I think we're out of time. Different places have tried to maintain certain types of or establish things that work for them. Emergency housing, domestic violence programs were able to at one point contract with hotels and motels, for instance, to provide housing when nobody was going to hotels and motels. That's evaporating now, and people are doing what they can with what they have.
Okay.
Thank
you.
All right. Thank you, Judge, and thank you, Jim. So Jim is a popular speaker. He's going to also speak on our second section, filing status issues and sources of evidence from family court. Jamie, Andree, I think you're going to begin, right?
That's correct. Thank you, Gina. I'm going to talk about filing status, specifically an issue that comes up frequently when spouse is divorced, and that is, will the spouses file a joint tax return? I'm going to discuss which filing statuses can be used by a married taxpayer and share some of the pros and cons of each filing status. So this issue comes up when the spouses have not gotten divorced by the end of the tax year. For example, it's currently still filing season for tax year 2019. If the spouses were not divorced before 2019 ended, they have to decide whether they will file a joint tax return for 2019. On the other hand, spouses who get divorced on or before December 31st of the tax year don't have to worry about this problem for that tax year. If they divorced before 2019 ended, then they're not permitted to file a joint 2019 return, unless, of course, they marry someone else before the year ends, and then they can file a joint return with the new spouse. The question of filing status can also come up because the spouses may have some unfiled tax returns for prior years. So they will need to decide whether or not they're going to file joint returns for those years as well. Filing status is important because it determines how much tax is owed and who owes it, or if a refund is due, how much the refund will be. There are some benefits, such as the Earned Income Tax Credit, which may be worth thousands of dollars to a married couple with children. And that benefit, for example, is not available may not be available because of a selected filing status. Choosing the wrong filing status can also lead to an IRS audit or a smaller refund or liability for more tax. Next slide. Married spouses are not required to file joint tax returns. Not everybody knows this. I've had many clients who did not know that they had a choice of whether to file a joint return with the spouse. Now, many spouses, particularly those who are not divorcing, choose to file joint returns and are happy that they did. But there are others who may decide that they're better off not filing a joint return with their spouse or soon-to-be ex-spouse. A married taxpayer has 3 filing status choices, and these are married filing jointly with their spouse, married filing separately, or head of household. The living arrangement between the spouses is irrelevant for married filing separately and married filing jointly. Spouses who live together can actually choose to file separately, and spouses who live apart can file joint returns if they choose. But this is not true with the filing status head of household. Living arrangement is relevant, as we will see in a couple of minutes. Taxpayers who were still married at the end of the tax year cannot choose the filing status single. So, if your divorce was final on December 31st, 2019, you can file your 2019 tax return as single. But if you weren't divorced until January of 2020, you can't file your 2019 tax return as single. You have to file either married filing jointly, married filing separately, or head of household, assuming you meet the specific requirements for head of household. Okay, next slide. A majority of married couples file joint tax returns because there are a number of advantages for doing so. And this slide lists some of the important advantages. In general, spouses will pay less tax or be due a bigger refund by filing jointly. Next slide. Next, yeah, thank you. Okay. There are, however, some risks to filing joint returns. When spouses file jointly, both are jointly and severally liable for the information that is shown on the return. It doesn't matter whether only one spouse had income or whether one spouse prepared the return and made errors. When spouses file jointly, they are both jointly and severally liable for any resulting tax due, whether that tax is shown on the return or whether it's added later with penalties and interests following an audit. And the IRS can pursue either spouse or only one of the spouses to collect any amount that's owed. Another risk to filing jointly has actually surfaced during the COVID pandemic, and that is that the economic impact payments for both spouses and for any eligible dependents that are claimed on the joint return are made in one payment. This particular issue is going to be discussed, I believe, by Nancy in more detail in a few minutes. Finally, the information in a jointly filed return is available to both spouses. So a spouse who has experienced abuse may not want to share private information, such as information about income sources or a bank account number, with the abusive spouse, and that may factor into whether or not the taxpayer wants to file a joint return. Okay, next slide. One advantage to using married filing separately or head of household if the qualifications are met is that the taxpayer who does so is only responsible for their own tax and is not jointly and severally liable with a spouse who may have concealed income from the IRS or made mistakes on the return, or who could have paid the tax due but decided not to. Okay, next. Now, this slide lists questions that a spouse, particularly a divorcing spouse, should consider before agreeing to file a joint return. I'm not going to read all of these questions, but I encourage you to do so. If a spouse is secretive, doesn't keep good records, controls the household finances, then there may really be some risks to filing jointly. However, a taxpayer who's knowledgeable about their spouse's income sources and trusts their spouse will likely face less risk filing a joint return. In the course of giving advice to a client who is in the midst of a divorce, what I will often find is that there are all kinds of things that the client doesn't trust, all areas where the client doesn't trust their spouse, but the client knows what the spouse's income is, and perhaps the client is actually in charge of the household finances. So the one thing the client may feel comfortable about is filing a joint return, but that is often not the case as well. For those of you who are representing clients in divorces, keep in mind that filing a joint return with a spouse is a choice. Remember, married couples don't have to file joint returns, and a tax professional can provide your client with the information that's needed to make an informed choice. Next slide. So I'm going to talk a little bit about head of household filing status. One advantage is there is no joint and several liability. A taxpayer who qualifies for and selects head of household is liable only for their own tax. Head of household is usually more advantageous than choosing to file married filing separately. For example, filing head of household still allows an eligible taxpayer to claim the earned income tax credit, which could not be claimed by a taxpayer using the married filing separately filing status. Next slide. Head of household does have more requirements. So to choose head of household, the taxpayer must provide the principal place of abode for at least one dependent. The taxpayer must also pay more than half the cost of keeping up the home during the tax year, and the taxpayer must also be unmarried. Now, what does that mean? Well, It means you have to have been no longer been married at the end of the tax year, or, as is frequently the case with taxpayers who are in the midst of divorce, they may still be married at the end of the tax year, but if they lived apart from their spouse for the last 6 months of the tax year or more, then they are considered unmarried and can choose to use the head of household filing status. Next. So, what that means is if your client was still living with the spouse in, say, August of 2019 and hadn't gotten divorced by the end of 2019, then your client isn't considered unmarried and can't choose head of household. Now, there is an exception for someone who was legally separated with a separate maintenance decree, and that does come up occasionally. If your client didn't provide the main home for a dependent for more than half the year, your client can't use head of household. If your client didn't pay more than half the cost of keeping up a home during the tax year, then they can't use the head of household filing status. Keep in mind that if your client does select head of household and the IRS audits the client's tax return, and audits often occur when the taxpayers claim the earned income tax credit, the client will have to prove to IRS that all of these requirements for choosing head of household status have been met. Okay, next. So the last topic that I'm going to address is whether a judge presiding over a divorce case can order the spouses to file a joint return. It's not clear how frequently this problem comes up, but I have represented several taxpayers who have found themselves in this situation, ordered to file a joint tax return when they did not want to or would have preferred not to do that. Now, why would a judge do this? I think there are a number of potential reasons. Perhaps one of the spouses, particularly the one with the most income, has asked the court to order the parties to file jointly because that spouse will owe less tax or get a better refund than if that spouse had been forced to file on their own because the other spouse wouldn't join in a joint return. It may also be that a spouse would ask for an order that the parties file a joint return because that spouse is abusive and might see it as a way to exercise control over the other spouse or get information about the other spouse's income or bank account. There may be cases where judges see married filing jointly as financially beneficial to both parties, or it may even just be standard procedure in some courts. But the problem with such an order is that one spouse may have some legitimate reasons to want to file a separate return. They may want to avoid joint and several liability for a tax debt. And this could be based on prior experience for that spouse who has filed joint returns in the past with the person to whom they're married and has ended up liable for tax. Or there may be privacy concerns, such as I mentioned earlier. Or your client might actually get a bigger refund if they don't file a joint return, particularly if that taxpayer can use the head of household filing status. Okay, next slide. This slide and the next one provide some legal authority discussing whether a judge can lawfully order spouses to file a joint return when one spouse does not want to do so. If you represent the unwilling spouse, keep in mind that federal law, specifically the U.S. Tax Code, does not require spouses to file jointly. It gives married taxpayers the right to file jointly or to file separately. Next slide. So if you are representing a spouse in a divorce, you've got the obligation to make sure that your client understands the pros and the cons of filing a joint return. And should the client not wish to file jointly, to raise this issue with the judge in appropriate proceedings. And the two secondary sources that are cited on this slide do provide some helpful arguments, or perhaps you'll be able to get help from a tax practitioner. There are all over the country low-income taxpayer clinics, many of which are located within legal services programs, who I am certain would be more than happy to help you convince a judge that your client should not be forced to file jointly with the client's spouse when the client doesn't want to do it. Next. I am now going to turn over the microphone to Jim, who is going to talk about how family law and tax practitioners can share records to advance the interests of their mutual clients.
Okay, thank you very much. Fundamentally, and most importantly perhaps, divorce, child custody records are, for the most part, it's public information. It's available to anybody. Rarely, on occasions, cases are sealed, but for the most part, it's public information. And it can contain, these files can contain a wealth of information, and probably most importantly, it's independently accumulated in a case that has nothing to do with the tax case. So it may be very useful in a tax case because people have made disclosures not thinking about their tax issues, and that may be then used against them in a tax case, or for them in a tax case, the fact that it's independent may provide some greater reliability to the information. Divorce and child custody cases, again, there's a wealth of information contained in these files, everywhere from the day of the marriage, the place of the marriage, separation, all sorts of child support calculations, perhaps. A UCCJEA affidavit is required in the Uniform Child Custody Jurisdiction and Enforcement Act, is required as an initial pleading for each party in a divorce or any kind of custody case, where a case where custody is involved. And in this affidavit, the parties are required to set out the address the child has lived at for the last each address the child has lived at for the last 5 years, and who lived there with the child. It may be very useful in issues where you're arguing about who gets to claim the child as a dependent, for instance. Child support is another issue. Whether it's a 4D case, it's brought through the welfare department, usually by married parents of children, or whether it's in a divorce or child custody case. Each state has a guidelines for child support now, and the link here is from that you can find the guidelines for your particular state. They vary substantially. However, and I can only speak to Alabama on this specifically, that first of all, an award of child support is per se an award of custody. And that may be the case in other states as well. It certainly makes sense. Even if the order is silent on the issue of custody, it is as a matter of law an order of custody. Beyond that, the child support guidelines, again, speaking in Alabama specifically, take into account the fact, and it is predicated on the parent receiving child support claiming the child as a dependent for purposes of taxes. So for the parent who's paying the child support to claim the child as a dependent, that would be a deviation from the guidelines that would require the court to make specific findings to support that. In the absence of that, the parent receiving child support gets to claim the child as a dependent. So that becomes part of the child support order. So if the parent paying child support files first, claiming the child as a dependent, the custodial parent, can file a return, and y'all can challenge that through the IRS and maybe in tax court. However, the fact that it becomes a part of the child support order strikes me that you can hand the case off also. You could do that, but have a family court lawyer pursue it as a contempt matter in the divorce or child support case. If the payor parent is claiming the child as a dependent, that is a violation of the child support order, which would put that person in contempt of court, and perhaps the state court judge could then order the payor parent who has wrongfully claimed the child as a dependent to file an amended return or face further sanctions from the court. It may be maybe butting heads with federalism and federal preemption, but I think it's certainly a course that might be worth taking. And if the payor parent is forced to file an amended return, I'm guessing that would resolve the matter and may resolve it even faster. The same thing applies to civil protection order cases, also applies to criminal cases. These are, for the most part, public records that can be accessible. Obtaining them, and it's going to vary obviously from state to state. More and more states have gone to central databases where you can access this data at the click of a mouse if you have access to it. Most lawyers who try cases in state court would have access to it. Legal aid lawyers would. There might be a nominal charge per page, but those are oftentimes, I think, waived for legal aid programs. They are in Alabama for the most part. So it may be easy if you have that kind of symbiotic relationship with a legal aid program to have the lawyers, legal aid, get the documentation for you. And again, symbiotically, certainly tax lawyers can provide meaningful information as well as certainly valuable consultation with domestic relations lawyers in representing their clients. I might also add the same thing may hold true for lawyers practicing bankruptcy. I think you can sort of wrap the client in these services, and I think that works to the benefit of victims and survivors of domestic violence. Thank you.
So there's more on criminal and civil records, but we don't want to shortcut our other presenters. And so now Nancy Rossner will give us a primer on the EIP. Nancy.
Great. Thank you, Gina. Thank you so much. So starting off with a brief EIP primer here, individuals receiving the stimulus or the EIP this year are actually receiving an advance payment of a 2020 credit that would otherwise be claimed on your 2020 tax return in 2021. under the CARES Act, when issuing the advance payment, the IRS is supposed to look at the taxpayer's 2019 tax return to determine their eligibility for the EIP. And if there is no 2019 return, the IRS is then supposed to look to the 2018 return. If the IRS did not file either, then they are supposed to look to other information such as Social Security information or information from Veterans Affairs in case eligibility may be determined that way. When determining eligibility, there are 4 main requirements as listed here on this slide, and we'll provide a little more detail on the next slides. So first up, valid identification number. So the taxpayer must have a valid identification number, and if they're a joint filer, then their spouse must also have a valid identification number. There is one exception to this, and that is if one of the spouses is a member of the armed forces. But when we're talking about a valid identification number, we're talking generally about a Social Security number without restrictions, as well as an ATIN, which is a tax identification number given to children put up for adoption or children being adopted. Next, the eligible individual cannot be a non-resident alien. So they either need to have status in the U.S. as a citizen or national, have a green card, or otherwise meet the substantial presence test, which looks at the number of days the taxpayer was present in the United States during the current year and the 2 previous years to determine status. Then there's also some income limitations. So there are no minimum earnings required, meaning if a taxpayer had no income in 2019 or 2018, they would still be eligible for the EIP. But there are some income limitations. So the taxpayers will only qualify for a reduced amount of the credit and eventually no credit once their income rises to a certain amount. Based on filing status, if a taxpayer's income is less than the amounts listed in black here below the table, they will qualify for the full amount of the EIP, assuming they meet all of the other criteria. But then as income rises above those amounts, the amount of the credit will be reduced. And the numbers in red show the caps for which the taxpayer will no longer qualify for the EIP if their income is above these amounts and the taxpayer has no qualifying children. Lastly, as far as the eligibility requirements go, the individual is one who may not be claimed as a dependent on someone else's tax return. So they're not looking at whether they were actually claimed as a dependent on someone else's tax return, but just whether they may be claimed as a dependent on someone else's tax return. And the way the law is currently being interpreted, an adult child who is disabled will not qualify for the EIP if they may be claimed as a dependent on another's tax return, like a parent's tax return. But due to their age, they will also not qualify as a qualifying child who would otherwise be eligible for the $500 EIP. So just as a reminder, the EIP being issued this year in 2020 is an advance of a 2020 credit that would otherwise be claimed on your 2021 tax return. So a child who is born this year in 2020 who may be claimed as a dependent on the taxpayer's 2020 return being filed next year should be eligible for a $500 EIP when that 2020 return is filed next year. So it will actually need to be claimed on the return to show eligibility, even though the parents may not be eligible to get the $500 this year because we're basing it on the 2018 or 2019 tax returns. So next, we're going to talk a little bit about the online portals, which some of you may be familiar with. I know some of us at LITCs have been helping taxpayers try to obtain their stimulus using these, and I've also spoken with legal aid attorneys that are doing the same, and even folks that aren't too much involved in tax, working at shelters and things, are trying to help taxpayers use these online portals to get their stimulus payment. And really, there's 2 important sections of the IRS portal for EIPs. So the circled section in this slide here pertains to non-filers or taxpayers who are not required to file a return for 18 or 19 and therefore didn't but are otherwise eligible for the EIP. Then the other section under Get My Payment can be used to enter banking information if it was not previously provided to the IRS. It can also be used to check the status of an EIP for which a claim has already been filed. But I think, it's not always clear, the status of the payment. Sometimes you use it and the IRS sort of has a blanket answer that they don't have enough information or you're not eligible. And that's sort of the boilerplate answer. So you may not get the most up-to-date information when using that portal. I have spoken with taxpayers who thought that because they were on a payment plan with the IRS before, that the IRS should already have their banking information for the stimulus. And I just want to be clear that that is not the case. The banking information needs to have been used on the 2018 or 2019 tax return or updated through the portal. Otherwise, the IRS will issue the stimulus check, will issue the stimulus payment either by check or by debit card. And generally, they're going to mail it to the taxpayer's last known address. So that's generally going to be the address used on the most recently filed tax return. I do know, though, that the IRS also does a sweep of change of address forms submitted to the post office. So it's also possible that they may get some updates that way. So what exactly is the portal? I think one of the more interesting legal questions that has arisen out of use of the portal has been whether or not the portal filing is by definition a tax return or not. And so as a resource on this debate, I refer you to Nina Olson's blog post here on procedurally taxing. One thing that we do know whether or not the portal filing is actually a tax return is that a filing through the portal actually blocks the taxpayer from then trying to e-file their own tax return. That's a problem. So this can be especially detrimental to low-income taxpayers who used the portal to get the stimulus, haven't filed a return yet for 2019, but then they want to file a return because maybe they have low income and children and would qualify for credits such as the earned income tax credit, which may be worth more than double the stimulus. This is something that the IRS is aware of and has been working on, and I know that this is one of the many things to which the ABA's tax section has drawn the IRS's attention, but it is my understanding that this is still an issue. With the July 15th filing deadline coming up, this means that if you are unable to file electronically, you will need to file by paper or file an extension. And as you may know, the IRS is not currently processing paper returns. So it can really be a dilemma, especially for low-income folks who use the portal thinking, okay, I'll do that to get my stimulus, then I'll file my return. And now they're finding they're unable to file the return electronically. They're left to paper filing, and now a lot of these paper returns are piling up in mail trailers that the IRS has been unable to get to just yet. So moving on to the next slide, where we're talking about marginalized and vulnerable taxpayers, there's another post I'd like to draw your attention to in which Nina Olson was a co-author, talking about some of these specific EIP issues that these low-income taxpayers are running into when trying to receive the EIP. And many of these concerns are issues that the tax section has identified in their comment letter to the IRS and Treasury that they sent in May. And I think we're going to try to link that in our materials for the slideshow. But of particular concern are transient taxpayers, unbanked taxpayers, unsophisticated taxpayers, taxpayers living in shelters, taxpayers who do not have access to resources to claim the EIP. And I think victims of domestic violence would fall under many of these categories where they're having issues for one reason or another trying to obtain their stimulus payment and they've been unable to do so. There are still an estimated 30 million to 35 million payments that have yet to be issued by the IRS, according to recent data on the progress of the payments from the House Ways and Means Committee. So we're going to talk a little bit now about identity theft. And there are a few different ways that identity theft can impact a taxpayer's ability to receive their EIP. In some instances, fraudulent 2018 or 2019 tax returns reporting improper bank accounts may be used to later issue the EIP. The fraudster may be an unscrupulous tax return preparer who altered the tax return, a complete stranger misusing another person's confidential identification information, or a partner or former partner. And these are just a few different examples of how tax information or personal information may be misused as far as taxes are concerned. And an abuser using the EIP to maintain power and control over their victim is a form of financial abuse, and it's one of the many methods that abusers may use to maintain power and control over their victim, as you saw in the power and control wheels at the beginning of the presentation. So here we have some practical tips about what to do if you think your EIP has been stolen as a result of identity theft. You can complete and submit Form 14039 to the IRS. This is the identity theft affidavit, and you should notate at the top of the form EIP 2020, that just to sort of give the IRS a heads up that this is related to the EIP. Unfortunately, a lot of the IRS campuses are still closed, and so it may be some time before the IRS is able to get through their backlog of mail and up to date on current submissions. Perhaps this is an issue, though, in which the Taxpayer Advocate Service would be able to help, and I think you should consider contacting your local office if you have this particular issue. Another helpful tip would be to institute a refund trace with the IRS, and you would do this using Form 3911. I have heard from other practitioners that said that they were able to do it verbally over the phone with the IRS, but it is possible that they may require the specific Form 3911 to initiate a refund trace. Doing this will enable you to get a copy of the cash check if the EIP was issued by check. So sometimes you can see if there's a fraudulent signature on it, or to get additional information about how the EIP was issued if you did not receive it, but should have. And I think this may later help as well if you're contesting your receipt of the EIP and you're trying to prove to the IRS that you are still due an EIP. I think many things with the IRS, it's about documentation. It's about documenting every step of the way so that later if that gets called into question, you can later refer to some of these records. And I just want to mention one example that I have of a client who recently contacted us. She's living in a shelter, and she believes that her foster family had fraudulently claimed her for the EIP. When she logged on to the IRS portal through one of the shelter representatives was assisting her, it said that she was not eligible for the EIP because her Social Security number had already been used to claim it. So in that situation, we're going to follow exactly the tips that I'm giving you here about using the identity theft affidavit, possibly doing a refund trace, all to detail exactly what's happening in this situation. So now I'm going to take a minute to discuss what I'm calling misappropriated EIPs. It's a bit different than an EIP that was stolen due to identity theft. And what I mean by misappropriated EIPs are EIPs that are issued by the IRS based on a joint 2019 tax return that was filed that is then deposited into a bank account to which only one of the joint filers has access. And this person refuses to release the portion belonging to the person with whom the joint return was filed. So often the situations that we're seeing, it's husband and wife, they file a joint return, husband is listed as the primary, and the refund goes into his account, and then, unbeknownst to them, a pandemic happens several months later, and stimulus payments go out, and now the stimulus is going into the account listed on the return, which happens to be the account of the abusive husband. we had exactly this issue come to our clinic, and the taxpayers had actually, they were going through divorce and had used IRS Form 8888, which can be used to split your refund into at most 3 different bank accounts. So they used that form to show the IRS they wanted the refund to be split equally between their 2 accounts. And then later, when the stimulus payment goes out, the IRS made a policy decision to only issue the stimulus to the first account listed on the tax return. So for our client, that was unfortunately the abusive ex-husband's account, and then he decided to withhold the payment from our client. So it's definitely a huge problem, and it's one that I know a lot of others are experiencing at legal aids and clinics and other areas nationwide. So moving on, as far as misappropriated EIPs goes, victims of domestic violence have less safe options available to them to resolve some of these EIP issues. Whereas some individuals may be able to consider options like small claims court, for example, that is less likely to be an option for a domestic violence victim given issues like these listed. Because of all these challenges facing victims of domestic violence, a very vulnerable population of taxpayers, the ABA has identified issues specific to this group in the comment letter issued to Treasury and the IRS on May 12th. And that's the same letter I mentioned earlier. So I do invite you to take a look. It is available publicly on the ABA website, and we're also going to link it in our materials. Not only are we concerned about the EIPs that may have been misappropriated already, but we also have concerns about the possibility of another round of EIPs that may be issued by the IRS using the same information used in the first round that we know may be wrong. It's important for us as advocates to continue drawing attention to this issue and raising them, not only to the IRS and Treasury, but also to our congressional representatives. And I do know that national groups like the National Network to End Domestic Violence, among others, have been meeting with congressional representatives to draw attention to this important issue. And I think we need to make sure that our voices continue on this issue. So, though some of those situations may seem kind of bleak, what can be done? What, if anything, can a taxpayer do if they find themselves in a situation in which their abusive ex-spouse is withholding their EIP? One of their options may be to file a superseding tax return. A superseding tax return is a tax return filed after an original return has been filed for the same year, but before the due date of the return. And the IRS will treat the second return as the return. Under the law, the taxpayer may file a separate tax return for 2019, even though a joint return may have already been filed for 2019. And we believe the benefit would be to establish that the EIP should not have been issued based on the married filing jointly return, and instead should be issued based on the timely filed separate return. So importantly, a superseding return must be filed by the due date. So this year, it's July 15th. It's coming up very soon, and that's why we really push to have the webinar. There's still some time left. So if you have a taxpayer or you have a client who's in this situation, you may want to consider filing the superseding return, and July 15th is going to be that crucial date. So you can use a superseding return to change the filing status from married filing jointly to married filing separately, or possibly to head of household if the taxpayer meets the criteria and the spouses have lived apart for at least the last 6 months of the year. If the goal is to change other things on the return, then normally you would have until the extended due date. So if you filed a timely extension, you would have until October 15th. But if you are filing a superseding return to change filing status, then that does need to be, the return does need to be filed by the due date with no extensions. So here we have some tips in the next slide on actually how to file a superseding return. And in most cases, your superseding return will be filed by paper if your original return was filed electronically, but I guess there could be some situations where maybe the original was filed by paper and then you could file the superseding return electronically. You're going to want to make sure to identify the return as a superseding return and actually write that across the top. And then here we have some sample language that I personally used in cases before where we were concerned that my client's spouse was going to file a fraudulent joint return and try to loop my client in on some debt. So what we did is we filed our client's separate return and attached this statement, basically to put it on record that our client was not consenting to any sort of joint return and that the separate return was the one that should be considered our client's one and only true return. So moving on to the next slide, we have some more information on superseding returns available through various blog posts, and you can use this slide as a resource to access them at a later time. And then moving on to the next slide, I do want to point out that a superseding return is not a panacea. So basically what that means is it's not going to be the answer. It's not, in every case, it's not always going to be the best course of action in every situation. One particular situation that we have identified is when the original 2019 return is a married filing jointly return in which the IRS issued the refund, including the earned income tax credit or the EITC. So this is a situation where you may want to take a second look and really consider if a superseding return is going to be appropriate. Because if the return is filed jointly, the EITC is issued, a large refund is distributed by the IRS, and then one of the taxpayers later files a superseding separate return, both returns will likely be changed to married filing separately, and the taxpayers will then no longer be eligible for the EITC. Now, we're talking usually thousands of dollars when we're talking about the EITC. So it's possible that the IRS may try to hold the taxpayers jointly liable for repayment of the EITC, even if only one of the taxpayers received it. I have some anecdotal evidence that may help, though. It gives me a little bit of hope. So I had a case a few years ago in which I was representing a husband who had moved out before the end of the year, and he left the wife and children in their family home. Early the next year, he filed a joint return for the family. According to him, what he and wife had agreed to do so. But turns out wife wasn't happy with the way he then split the refund with her, and she filed her own separate return for the same year prior to the filing deadline. So he filed jointly. Her separate return was then treated as a superseding return. His tax return was audited as a result. So that's just a heads up that if the superseding return is filed, it may trigger an audit. And then his wife ended up getting her separate refund, and surprisingly, she was not held jointly liable for repaying the refund based on the joint return. So it's important to note here that it is possible that a superseding return will open up an audit, though probably more likely for the original joint filer. And I suspect that in my case, the wife may have alleged that the joint return that was filed was not valid, and maybe that's why my client was then held solely responsible to return the refund to the IRS, and wife was not. So again, this is anecdotal evidence, but I think to me as an advocate, it is worth trying to utilize every legal option we have to help our clients, even if we don't know with certainty how the IRS will proceed. So if a superseding return is possibly an option, definitely something to consider. So I think okay. I'm going to go ahead and pass this. I was about to pass it back to you, Gina. Thank you.
Thank you. So there are lots of good questions coming in. If you have more detailed questions, the panelists have said that they will make themselves available, and the ABA will email us the questions. So don't worry if we don't address your question right now. And just really quick, we wanted to highlight that there is a new news release, IR 2020-93, which hints at the possibility that there may be one payment issued. News releases are not law, so take it with a grain of salt. And Jill MacNabb, the senior attorney from the IRS Taxpayer Advocate Service, will share with us about innocent spouse release. Thank you.
Thanks, Gina, and thanks to everybody who preceded me in setting this up. I just wanted to go over with you very quickly what you can do to help your client who has already filed a joint return. So, we know from Jamie's discussion that we've got joint and several liability from that. We're not talking about a superseding return. So let me just go to the next slide. The relevant section here will be Code Section 6015, which talks about innocent spouse relief, and there are basically 3 subsections. I want to flag for you in particular that you need to reference Revenue Procedure 2013-34, which applies when you're looking for equitable innocent spouse relief, which is probably the majority of the cases, because it does set out that one of the factors the IRS will consider is whether the requesting spouse knew or should have known about the understatement or the underpayment. And the guidance provides that abuse or financial control will result in that factor, that knowledge factor, weighing in favor of relief, even if the spouse requesting the relief knew or had reason to know about the items, that gave rise to the understatement or that the liability wouldn't be paid. And also, where abuse is shown, relief can be available even where the understatement or the underpayment was attributable to that requesting spouse. And then the only other thing I want to flag to you here is that under this guidance, that revenue procedure, there has to be a nexus between the abuse and the tax return. The guidance says that the requesting spouse has to establish that he or she was the victim of the abuse prior to the time the return was filed, and that as a result of that prior abuse, the requesting spouse was not able to challenge the treatment of any items on the return, or was not able to question the payment of any balance due for fear of the non-requesting spouse's retaliation. So we've just seen some cases recently in which a spouse is able to show that there was abuse, but the IRS countered by showing that the abused spouse was actually in control of the family finances, perhaps even filing the tax return. So in those cases, abuse may not negate the fact that the requesting spouse knew or should have known about the liability. So that knowledge factor may weigh against granting relief. Now, that doesn't necessarily mean that relief is not available, but just that one factor may weigh against granting relief. Just wanted to flag that for you. So moving on, let's see. Go to the next slide. Another avenue you could use is different. It's to demonstrate that a joint return was not actually filed. So you could, if you could demonstrate that the return was signed under duress, that is what you would have. In this situation, you're no longer seeking innocent spouse relief. You're seeking to establish that there was never any joint liability. So you can see the requirements for doing that. Just as in the superseding returns, if you do succeed in showing duress, the IRS will adjust the accounts for both spouses to treat them as married taxpayers filing separate returns, and that the demonstrating duress could trigger an audit. Okay. Similarly, we have the same thing if you succeed in showing that a signature was forged, as long as you're able to show that there was no tacit consent. So this slide has the relevant information in the Internal Revenue Manual, and I'll talk to you in a second about tacit consent. But essentially, the inquiry is into the circumstances surrounding the return, such as how the return was prepared and whether there were benefits to filing the return. So here we have in the next slide the description of tacit consent. Basically, your client may not have actually signed the return, but the consent to file the return can be inferred. And there's the third bullet there has a cited case that's pretty recent. It's very interesting, though, because here, in that case, the IRS agreed with the taxpayer that she was entitled to innocent spouse relief, and there was also abuse. It was the other spouse who claimed that there was no tacit consent and thus no joint return, because the other spouse wanted the income and the deductions to be calculated as if the couple had filed separate returns. But anyway, the taxpayer seeking relief won that case. But it's an interesting read. Also, I wanted to flag for you that when you think forgery, you may think of identity theft. I wanted to flag for you that if you are seeking innocent spouse relief and that if you also allege identity theft, the identity theft issue will be resolved before the innocent spouse claim can be worked. So in other words, if the innocent spouse unit receives a request for innocent spouse relief and an identity theft affidavit, they will not process the innocent spouse claim. They'll return that to the taxpayer until after the identity theft claim has been resolved. Here's your let's see here. Next slide. What do we have? Okay. I think we can go to the next slide too. I wanted to talk to you for a second about disclosure. There are some rules here you need to be aware of. Privacy concerns obviously are heightened when there's abuse. So if you decide to seek innocent spouse relief under Section 6015, you need to know that the IRS will communicate with the other spouse. So it's this Treasury regulation that requires the IRS to notify the other spouse of the request for relief. There's no exceptions here. The spouse can be heard. They can submit information that should be considered. And the IRS will have to inform the other spouse about its preliminary and final determination. The non-requesting spouse cannot petition the tax court from the IRS's determination to grant innocent spouse relief, but can intervene in that tax court proceeding. Okay? And finally, let's take a look at the other main disclosure provision under the Code Section 6103. Those are general non-disclosure rules, but there are exceptions where there has been a joint return. Joint filers can see the joint return, and they may be able to learn whether a deficiency has been collected from the other joint filer. However, and this might be of some consolation, if you go to the next slide, the IRS will not disclose all of the information that it has. For example, and these couple of IRM provisions show you what the IRS will not disclose, will not tell, the other spouse's location, name change, phone number, employment, and the things that are listed there on the slide. So yes, there is some disclosure, but it's counterbalanced by some of these provisions. So I think I raced through that, Gina. Is that? I'm sorry to do that, but the slides are there, so if you want to consult with them. And of course, I'm happy to help anybody with any questions.
No, that was very, very good. I'm impressed. I actually think there are a lot of very good questions, but I haven't had a chance to ask panelists if they're okay with getting them softballed right now. So panelists, please look through it as I go through the next slide on advice and options available for clients. It's just a really quick summary. And then we will go to question and answers. Please do type in your questions, because then we will have your registration info, and anything we can't get to now, we'll do our best to get back to you privately through email. So it looks like some of the things we've learned through this is that e-filing, there is a race to e-file. And if you happen to have a client that is very diligent, try to help them e-file fast before there is a competing spousal return. There is an ID theft phone number right here and a link to it. More information. Something new that I personally learned is that there's an informant referral that even spouses can use to report their ex or abuser spouse on different, perhaps, potential tax violations going on. Try to maximize family court records and get to know your family court legal aid practitioner. Maximize the IRS forms. On the materials that we're not going to go over in the slide, there's a list of forms that we thought might be helpful to domestic relations practitioners, and the refund trace is also an option. Before, I just wanted everyone to pipe in, if possible, if there's one point the panelists want to highlight, because there's a whole slew of information. And it's like when you go to a conference, you can't remember anything except for one thing. If there's one thing you wanted to highlight and emphasize for our attendees today, can I ask if any of the panelists would like to jump in and say something? We have about 2 minutes.
Okay, this is Bernadette D'Souza. And one point that I think every lawyer should remember is understanding the dynamics that play within domestic violence situation. For family lawyers to, recognize also that safety really becomes paramount in a lot of these DV cases. And for tax lawyers to work really closely with the family lawyers to obtain all the necessary documents so that you can represent the victim spouse obtaining the necessary relief that they're entitled to. And thank you so much for the kind invitation to participate on this wonderful webinar.
This is Jamie.
Thank you. Yes, Jamie.
So the point I'd like to make is there is a great deal of overlap between family law and tax. Tax problems can severely impact economic security of domestic violence survivors even after they are able to escape their abusers. Family law practitioners and tax practitioners make excellent partners. They can provide information and training to each other, and so I encourage all of you, whether you are a family practitioner or a tax practitioner, to get together and work together. And for those of you who are in legal services programs or representing low-income spouses, don't forget that there are low-income taxpayer clinics which will provide free legal assistance to your family law clients with their tax problems.
Okay, and that was the perfect lead-in to that's all the time we have for today. But before we leave, I wanted to ask all the attendees who want CLE credit to stay connected for instructions to get your certificate. Also, please wait for the evaluation to come up on your screen. To our faculty and this program, to the Bar Association and Section of Taxation, we want to say our thank you, especially to the participants, the legal aid, social workers, LITC, and pro bono. We appreciate you, and thank you for joining us. I will now turn you over to our operator for additional information. And don't forget to type in your questions because we'll try to get back to you through email.
Thank you. On behalf of the American Bar Association and the ABA section of taxation, thank you for participating in this program. To learn more about the sponsors, visit the ABA website at www.americanbar.org. Thank you, and please click on the evaluation link. We value your feedback.